Hello, this is the Kelso Report's preview of the United States Supreme Court's October term, 2011. I'm your host, Clark Kelso. Well, the Supreme Court has already granted a review in about 48 cases for this term. That gives it another 30 or 35 slots to fill. And there still are some pretty important cases that the Court may grant review in this year. For example, I think we're all aware the Court may grant review in one of the cases involving Obama's health care to look at the constitutionality of it under the Commerce Clause. The Court may take up a gay marriage case this year. It won't be the one from the Ninth Circuit, but it might be a case under the Defense of Marriage Act. And the Court may take up an important affirmative action case this year. There's some cases that involve affirmative action in higher education that would give the Court another chance to take a look at that issue. If the Court were to grant review in any or all three of those areas, this would be a really blockbuster term. And as it is, we already have a set of pretty interesting cases coming up before the Court. So let's get to those cases and take a look at what the Court has already granted review in. First, let's begin with some civil procedure cases. In Reynolds v. United States, we have a standing question. Whether the plain language of the Sex Offender Registration and Notification Act gives the petitioner the standing to raise a claim regarding the retroactive applicability of the Act. Next, we have in First American Financial Corp. v. Edwards, question arising whether a private purchaser of real estate settlement services has standing to sue under Article 3 of the United States Constitution, in the absence of any allegation that the violation of the Act affected the price, quality, or other characteristics of the settlement services provided. So absent any statutory injury, is there really standing? Sounds like a pretty interesting case. Next we have in Taniguchi v. Can Pacific Saipan the question of whether the costs incurred in translating written documents are compensation of interpreters, which may be therefore awarded as costs to the prevailing party in a federal lawsuit. We have so far only one arbitration case. The Court's taken more than one in the last couple of years, but right now just one, in CompuCredit v. Greenwood, whether claims that arise under the Credit Repair Organizations Act are subject to arbitration pursuant to a valid arbitration agreement. The Ninth Circuit in this case said no, they're not subject to arbitration under the Act. The Supreme Court's taken the case. My guess is they'll reverse and apply the general principle that federal law favors arbitration agreements under the Federal Arbitration Act. We'll see what they do there. We have two preemption cases. First, National Meat Association v. Harris, where they're going to take a look at whether the Ninth Circuit misinterpreted the Federal Meat Inspection Act's express preemption provision. The Ninth Circuit gave it a narrow interpretation, which seems to be contrary perhaps to the Supreme Court's decision in Jones v. Rath Packing, suggesting that an express preemption provision should probably be given a broader meaning. In particular, the question is whether federal food safety and humane handling regulations that specify what you're supposed to do when an animal becomes non-ambulatory, whether you're supposed to follow that rule or a state rule that says those animals should be put down and immediately euthanized. So who prevails here, state or federal law? Second preemption case, Kearns v. Railroad Friction Products. Question here is a simple one. Did Congress intend the Federal Railroad Safety Acts to preempt state law-based tort lawsuits? Here there's a tort lawsuit involving exposure to asbestos. But there's a long line of cases holding that the Railroad Safety Acts and their predecessor, the Boiler Acts, were intended to be to preempt the entire field. And the Supreme Court's going to decide that question here in Kearns. Right now we have only one securities law case, Credit Suisse Securities v. Simmons, involving a limitations period. Question is whether a 2-year statute of limitations established in Section 16B of the Securities and Exchange Act, which requires statutory insiders to disgorge profits from short swing transactions, whether that begins to run if the targeted insider failed to comply with its obligation to disclose the short swing trading activity in its SEC reports. My guess is that if they fail to disclose, that doesn't start the limitation period. That will be told during that period, would be my guess. We have a couple of taxation cases here. The first one involves the interaction between the Internal Revenue Code and a bankruptcy filing issue in Hall versus United States. Really, it's a question of whether in a particular type of bankruptcy filing it gives rise to a separate taxable entity, and what's the impact of that upon capital gains income. The second taxation case, U.S. versus Home Concrete and Supply, is whether the understatement of gross income attributable to an overstatement of the basis in sold property is an omission from gross income that can trigger the extended 6-year assessment period. My guess is going to be yes, it does trigger the extended 6-year assessment period. Either way, it ends up being an understatement of your gross income, whether it's by simply failing to report income or increasing the reporting of your basis in your property. We have one remedies case this year so far in FAA versus Cooper, where the question here is whether a plaintiff who alleges only mental and emotional injuries, intangible injuries, can establish actual damages within the meaning of the civil remedies provision of the Privacy Act. That'll be interesting to watch, because oftentimes mental and emotional distress damages really are all you get from a violation of privacy. We have one church and state case at this point, Hosanna Tabor Church versus EEOC. Here the question is whether the ministerial exception, which prohibits most employment-related lawsuits against religious organizations by employees performing religious functions, applies to a teacher at a religious elementary school who teaches the full secular curriculum, but also teaches daily religion classes, is a commissioned minister, and regularly leads students in prayer and worship. It seems to me that's someone who's performing quite a few religious functions. We have 3 intellectual property cases so far. Golan versus Holder, where the question is whether the Progress Clause of the United States Constitution prohibits Congress from taking works out of the public domain and reinstating copyright protection. This was done as part of the Uruguay Round agreements in order for us to comply with international law and agreements in copyright. We had to reinstate copyright protection for things that were in the public domain. So it'll be an interesting question what prevails there, our international obligation or the notion that once it's in the public domain, it's free for all of us to use. Next, in Carrico versus Novo Nordisk, the question is whether the counterclaim provision of the Hatch-Waxman Act applies when there is an approved method of using a particular drug that the patent does not claim, and the brand then submits patent information to the FDA that misstates the patent scope, requiring correction. This really deals with technical matter dealing with how patents for drugs are actually regulated by the FDA. Next, in Mayo versus Prometheus Laboratories. Question here is whether Section 101 of Title 35 is satisfied by a patent claim that covers observed correlations between blood test results and patient health, so that the claim effectively preempts all uses of a naturally occurring correlation, simply because well-known methods used to administer prescription drugs and test blood may involve, quote, transformations, close quote, of body chemistry. In essence, how much are you going to be able to patent? Can you patent something that really is a naturally observed correlation? And then we also have Kapos versus Hyatt. And the issue here is going to be whether a plaintiff who is appealing the denial of an application of a patent by commencing a civil action against the director of the United States Patent and Trademark Office may introduce new evidence that could have been presented to the agency in the first instance but wasn't. And whether, when new evidence is then introduced, the district court may decide de novo the factual questions to which the evidence pertains, without giving deference to the prior decision of the PTO. My guess here is you can't just present new evidence and have the district court rule on it. It should have been presented initially to the PTO. I think that case goes back to the Patent and Trademark Office. We have one case involving communications law, sort of a fun one, whether the Court of Appeals erred in invalidating a finding by the FCC that a broadcast that included expletives and some nudity was indecent within the meaning of statutory and regulatory prohibitions on indecent broadcasts, on the ground that the FCC's context-based approach to determining indecency is unconstitutionally vague in its entirety. We'll get a chance to see whether the FCC does any better with indecency than the Supreme Court has done with obscenity. We have one straight health law case. As I said before, it may be they'll take up the federal health care reform, but right now the only cases they have dealing with health law come out of California and our budget problems out here. And really the question is whether Medicaid recipients and providers can maintain a cause of action under the Supremacy Clause and assert that federal statutory provisions preempt our state budget, which attempts to reduce reimbursement rates. So that'll be a very important case for our budget. It actually gets argued on the first day of the court's term, October 3rd. Maybe we'll get a sense from the argument about where the court's going to go with that one. We have 8 cases dealing with sort of government law liability issues. First, in Rehberg versus Polk, whether a government official who acts as a complaining witness by presenting perjured testimony against an innocent citizen is nevertheless entitled to absolute immunity from a Section 1983 claim for civil damages. I certainly hope not. I hope at best it's qualified immunity and that you lose it by presenting perjured testimony. But we'll see what the court does with that one. Next, in Minechi versus Pollard, the question is going to be whether the court should imply a cause of action under Bivens against individual employees of private companies that contract with the federal government to provide prison services. When the plaintiff arguably has adequate alternative remedies for the harm alleged, and the defendants have no employment or contractual relationship directly with the government. The Supreme Court's not been too wild about extending Bivens claims over the last decade, so I'd be surprised if they extend it to an employee of an independent contractor. Next, in Messerschmitt versus Millender, the question here is whether police officers are entitled to qualified immunity when they obtained a facially valid warrant to search for firearms and gang-related items in the residence of a gang member and felon who had threatened to kill his girlfriend and fired a sawed-off shotgun at her. The question really is also going to be whether the Supreme Court should reconsider some of its good faith exceptions from United States versus Leon and Malley versus Briggs. Our next case, PPL Montana versus Montana, will give the court the chance to consider the constitutional test for determining whether a section of a river is navigable for title purposes. And the question is going to be whether the relevant stretch of river was navigable at the time the state joined the Union. Or is that the right test, or is it going to be something that's a little more recent? We're going to have one of those cases that takes us way back in time. Next, in Coleman versus Maryland Court of Appeals, the question here will be whether Congress constitutionally abrogated the state's 11th Amendment immunity when it passed the self-care leave provision of the Family and Medical Leave Act. Congress does have power to abrogate that immunity, but it has to do so clearly and unmistakably. And we'll see if they did that in this particular case. Next, in Filarski versus Delia, the question's here whether a lawyer who was retained to work with government employees in conducting an internal affairs investigation is precluded from asserting qualified immunity solely because of his status as a private lawyer rather than a government employee, a little bit like the case described earlier with the employees of the company that's providing prison services. We'll see how the court handles that one. Next, in Sackett versus EPA, the question here is whether petitioners may seek pre-enforcement judicial review of an administrative compliance order pursuant to the APA, and whether, if not, petitioners' inability to seek pre-enforcement judicial review of the administrative compliance order violates their rights under the Due Process Clause. Next, we have in Knox versus SEIU, a question that has come up quite a bit over the last decade. May a state, consistent with the First and 14th Amendment, condition employment on the payment of a special union assessment intended solely for political and ideological expenditures, without first providing a notice that includes information about that assessment and provides an opportunity to object to payment of it. This is an issue that's been up before the Supreme Court before in the context of private employers and unions. Here, the issue is coming up in the context of public employment. Well, we have one foreign relations case this year so far. The case is MBZ versus Clinton. And the question is whether the political question doctrine deprives a federal court of jurisdiction to enforce a federal statute that explicitly directs the Secretary of State how to record the birthplace of an American citizen on a consular report of birth abroad and on a passport. The related question is whether Section 214 of the Foreign Relations Authorization Act impermissibly infringes upon the President's power to recognize foreign sovereigns. We have, of course, a large number of habeas corpus cases. This year we've got 7 so far. Howes versus Fields is the first. And the issue here is whether the court's clearly established precedent holds that a prisoner is always in custody for purposes of Miranda warnings anytime that prisoner is isolated from the general prison population and questioned about conduct occurring outside the prison, regardless of the surrounding circumstances. Sure looks like he's in custody to me, but we'll see what the court says about that in terms of a Miranda warning. Next, in Martinez versus Ryan, questions whether a defendant in a state criminal case who is prohibited by state law from raising on direct appeal any claim of ineffective assistance of trial counsel, but who does have a state law right to raise such a claim in their first post-conviction proceeding, therefore has a federal constitutional right to effective assistance of first post-conviction counsel, specifically with respect to his ineffective assistance of trial counsel claim. Sort of like, you're entitled to have at least one constitutional protection for your ineffective assistance of trial counsel claim. Somehow I doubt that constitutional right exists, but we'll see what the court does. Next, in Green versus Fisher, for purposes of adjudicating a state prisoner's petition for federal habeas relief, what is the temporal cutoff for whether a decision from the Supreme Court qualifies as clearly established federal law, as amended by the Anti-Terrorism and Effective Death Penalty Act? So we'll see what the court says about the time that their prior decision must be clearly established. Next, in Lafler versus Cooper, question here is whether a state habeas petitioner is entitled to relief when his counsel deficiently advises him to reject a favorable plea bargain, but the defendant is later convicted and sentenced pursuant to a fair trial. So I guess the question is, once you've decided not to do that plea, can you unring the bell that you've actually been convicted and sentenced pursuant to a fair trial? I doubt the Supreme Court's going to go along with that. In Gonzalez versus Thaler, the question here is whether there's jurisdiction to issue a certificate of appealability and to adjudicate the petitioner's appeal when the application for writ of habeas corpus may have been out of time due to the date on which the judgment became final by the conclusion of direct review. So there's going to be a timeliness question here. These sort of issues can be pretty tricky because they depend upon, quite a bit, upon how state law determines timeliness of its various petitions. Next, in Smith versus Kane, the question is whether there's a reasonable probability that the outcome of his trial would have been different but for Brady and Napoo errors. And the related question, of course, whether the state courts violated the Due Process Clause by rejecting those particular claims. Next, we have in Martell versus Clare, whether a condemned state prisoner in federal habeas corpus proceedings is entitled to replace his court-appointed counsel with another court-appointed lawyer just because he expresses dissatisfaction and alleges that his counsel was failing to pursue potentially important evidence. Is that enough to get new counsel, or do you need something more? My guess, that's not going to be enough to get new counsel. That'd be a little bit too easy to game that system. Well, we have 3 criminal procedure cases so far. First, Missouri versus Fry. The question here is whether a defendant who validly pleads guilty can he assert a claim of ineffective assistance of counsel by alleging that but for counsel's error in failing to communicate a plea offer, he would have pleaded guilty with even more favorable terms. And then if so, what remedy should be provided for that sort of ineffective assistance of counsel during plea bargain negotiations? My guess is here, so long as it's a knowing and effective plea, that's going to be the end of the matter. Next, in Perry versus New Hampshire, the question is whether due process protections exist against unreliable identification evidence, and whether those apply to all identifications made under suggestive circumstances, or only when the suggestive circumstances were orchestrated by the police. That'll be a close call. Seems to me a pretty good argument that if they are objectively suggestive, due process protection should apply. The motivation of the police really shouldn't enter into that. But we'll see if that's what the court does. Next, in Williams versus Illinois, the question here is whether a state rule of evidence that allows an expert witness to testify about the results of DNA testing performed by non-testifying analysts violates the Confrontation Clause when the defendant had no opportunity to confront the actual analyst. Seems to me it does violate the Confrontation Clause. I think the court will so hold. Next, in criminal sentencing, right now we only have one of these cases. Usually the court takes 3 or 4, but right now just one. Setzer versus United States. Whether the district court erred by directing that petitioner's federal sentence be served consecutively to a state sentence that had not yet been imposed. Seems to be the federal court got out ahead of itself here, and I'm hoping and expecting the Supreme Court will reverse the district court's action in this case. We have a couple of search and seizure cases, both pretty interesting. The first, Florence versus Board of Freeholders, whether the Fourth Amendment permits a jail to conduct a suspicionless strip search whenever an individual is arrested, including for minor offenses. Seems to me a strip search is pretty extreme invasion of privacy for a minor offense. We'll see whether the alleged interest in jail safety is enough to trump that invasion of privacy. Next, in U.S. versus Jones, the question here is whether the warrantless use of a tracking device on petitioner's vehicle to monitor its movements on public streets violates the Fourth Amendment. In this particular case, they had installed a GPS tracking device on the vehicle without a valid warrant and without consent. It seems to me that is a violation of the Fourth Amendment. I know I'm on a public street, but I don't expect a GPS tracking device to be attached to my car. This may be one of those cases where new technology has gone beyond the Fourth Amendment. Even Justice Scalia at times expresses concerns about new technology essentially taking away zones of privacy that we believe exist. We got 3 immigration cases, Judelang versus Holder. Whether a lawful permanent resident who was convicted by guilty plea of an offense that renders him deportable and excludable under certain differently phrased statutory subsections, but who did not depart and re-enter the United States between his conviction and the commencement of removal proceedings, is categorically foreclosed from seeking discretionary relief from removal under former Section 212C of the Immigration and Nationality Act. Extremely technical question involving the interaction of a number of different ways in which you can be removed, deported, and yet still seek discretionary relief. Next case is Kawashima versus Holder. That's where the Ninth Circuit had held that the petitioner's convictions of filing and aiding and abetting in filing a false statement on a corporate tax return in violation of Title 26 U.S.C. 7206, whether those are aggravated felonies involving fraud and deceit, such that petitioners were therefore removable. Seems to me filing a false return sounds like fraud and deceit to me. We'll see what the Ninth Circuit does. What the Supreme Court does. Next, in Holder versus Gutierrez, the question is whether a parent's years of lawful permanent resident status can be imputed to an alien who resided with that parent as an unemancipated minor for the purposes of satisfying Title 8 U.S.C. 1229B's requirement that the alien seeking cancellation of removal have been an alien lawfully admitted for permanent residence for not less than 5 years. And of course, similarly, whether you can impute that time for the requirement that you reside in the United States continuously for 7 years after having been admitted in any status. In other words, you get the credit for those years if you're a minor living with an alien. Seems to me you should get credit. We'll see what the Supreme Court does. Well, that's it for the preview of the Supreme Court's 2011 term at this point. Throughout the year, we will be updating you as the Supreme Court grants review in additional cases. We look forward to seeing you for those broadcasts. I'm your host, Clark Kelso. Have a great day in the law.